the last person I need to introduce is Sabrina Hamm, who is the Director of State Policy and Advocacy at Free From, which is an organization based in Los Angeles, actually founded by a Berkeley alum. So we love Free From. Free From works to create pathways to long-term safety and financial security for survivors of intermittent partner violence. She and Sabrina has worked to lead Free From state-level policy initiatives with a goal of passing survivor wealth-centered legislation in every state. I apologize that you could not hear me for those of you online, but now we're going to move on to our program. So first, we're going to have Professor Littwin share with us what is coerced debt.
Okay, so you should all be able to see my slides now. Can we confirm? Okay, great. All right, so what is coerced debt? Adrienne Adams, my long-term research collaborator, and I define coerced debt as all non-consensual credit-related transactions that occur in a relationship where one person uses coercive control to dominate the other. So we see it as the intersection of coercive control and consumer credit. Now, you as law students probably know what consumer credit is, but you may not know what coercive control is. It's a type of domestic violence in which one partner uses the systematic, ongoing use of violence, isolation, intimidation, and control to restrict the victim or survivor's autonomy and liberty. It's basically trying to undermine their free will. Coerced debt is one species of economic abuse, which is sort of a broader category. And economic abuse is behaviors that control a person's ability to acquire, use, and maintain economic resources, right? It's when an abusive partner imposes behaviors that make that more difficult. And Adrienne's research has found sort of two types of economic abuse: economic restriction and economic exploitation. Restriction is doing things like keeping people away from their access to money, right? So interfering with income, interfering with job, dictating spending, hiding money, hiding financial information. Whereas exploitation is when the abusive partner actually uses the person's money or credit, right? So stealing money or property, and creating debt in the person's name is part of that, right? So coerced debt is at the intersection of consumer credit and coercive control, and it's also a species of economic abuse. To say a little more about that, I'm going to get into just a little bit about how it's created. So we sort of think of three main mechanisms, although there's obviously some overlap, right? Taking out loans in the partner's name, taking out credit cards, which are obviously a form of credit too, but also using credit cards in a partner's name, and then putting bills like household bills in a partner's name and leaving them to pay it. In our most recent study, I interviewed a woman who was coerced by her now then ex-husband, but then husband, to take out probably twice as much money as she wanted to in her student loans. And he had previously taken control of their finances. And if she didn't agree to take out twice as much money and take out the max in the student loans and turn over everything that wasn't going to her tuition to him, he wouldn't be allocating her any money for food for that month or anything, right? I had interviewed another person whose then husband they would go to a car dealership to buy a car, and her husband would throw a tantrum like a toddler, screaming, banging on things, etc., until she would give in to avoid dying of embarrassment and get the more expensive car that he wanted. Um, Credit card, we saw sort of rampant people stealing, ex-husbands stealing stealing their wives' credit cards, taking out credit cards without them knowing. Putting bills in partner's name. I interviewed somebody who, when we went through her credit report, she found a cable bill that was with a provider that she had never had cable with. And she then looked at the dates of the cable bill, and they were from when she had moved out of the apartment she shared with her ex-husband to when her ex-husband had moved out of that apartment, making it very likely that he had just put the cable bill in her name. So you've heard me mention some mechanisms, and we sort of think of three main mechanisms as establishing coerced debt. There's fraud, or in sort of legal terms, people think of it as identity theft, right, which is using a partner's personal information, take out credit in their name without their knowledge. Coercion, in which you use force or threat of harm to compel someone to take on debt they would not have otherwise incurred. So coercion we define with a two-part test: a demand to take out debt, right? Sign your loan name on this leaving loan application, for example, and a threat. And the threat could be physical harm, financial harm, psychological harm, and that those two things together make for coercion. And then the third is manipulation, is deliberately managing conditions or information to lead a partner to take out debt she would not have otherwise incurred. For example, Adrienne interviewed somebody in our earlier study who she was an immigrant, and her then husband told her everybody has student loans and everybody borrows to the max, and this is just how it works in the United States, and wouldn't give her access to the balance, and she wouldn't tell her how much she was borrowing. But he was using physical coercion, but also lies to sort of make her think that this was a normal thing to do in the US. So we think of debts, everybody thinks of debts with coercion as being coerced debt, but we also include debts created by fraud, and manipulation, because coercive control can facilitate those transactions and make them harder to deal with, right? So when you have coercive control, under a fraudulent transaction, for example, the survivor may learn about the fraud, but questioning her partner about the credit card charges may mean risking harm, right? So the coercive control ends up facilitating the fraud. Coercion, right? Refusing to take responsibility for a bill or buy something on credit means risking harm. And then manipulation, questioning whether, for example, taking out a student loan is really the best option, means risking harm. And so it's the coercive control as an umbrella state of the relationship that enables all of these three mechanisms to generate coerced debt. And that is what I have so far, but I will be happy to take questions at the end if others go.
Awesome. Thank you so much, Professor Littwin, for that little primer on coerced debt. Next, we are going to have Erica Sussman talk about recent data on research on coerced debt during COVID, the ripple effect on survivor safety, and some of the advocacy and systems change efforts. So if you want to stop sharing, Angie.
I'm trying to do that. I'm not able to get the controls up for some reason. Oh, here we go.
Thank you.
Okay.
Great. Good afternoon, everybody. As Eliza mentioned, I'm Erica Sussman, and I'm the founder and the executive director of the Center for Survivor Agency and Justice. It's a real pleasure to be on this panel because everybody who is part of this has really played a really fundamental role in both identifying as well as working to address this pernicious issue of coerced debt. So I'm really honored to be here with you all. Just as some background, what I'd like to talk about really is about how things have evolved a little bit in terms of the movement's approach to coerced debt, as well as some ways that it's shown up recently during the pandemic, and some of the systems efforts in that respect. So just to give you a sense of where I'm entering this, so CSAJ is a national organization, and we sit at the intersection of gender-based violence and economic equity. We do our work through 3 different levels of impact, helping to embolden individual advocacy, strengthening organizational and community responses, and also fueling systems and policy change to advance economic equity for survivors of gender-based violence. Survivors of domestic and sexual violence experience profound economic harms that extend far beyond the short term and compound over the course of time in what we have come to call the economic ripple effect of domestic violence. What we've seen most recently is that the pandemic exacerbated this economic ripple effect for survivors, deepening pre-existing disparities. And survivors have been uniquely and disproportionately impacted by the economic fallout of COVID, meaning that they didn't have the means to address past economic hardship, including coerced debt. So for example, in a study that we conducted during the course of the pandemic, a national survey on the economic impacts of COVID on survivors, some of the top 3 challenges that survivors have faced include lost income, about 96% reporting that, inability to pay bills, 94%, and trouble getting enough food, 87%. All of these obviously very much connected to debt and very much connected to survivor safety and well-being. So just to take a step back in terms of how we've approached this issue in collaboration with advocates, programs, state coalitions across the country, over the past decade and a half, we have worked to leverage the power of consumer law to address this economic ripple effect. So in 2007, we found ourselves in a room very much like the one that I'm seeing on the screen here, where domestic violence and consumer lawyers were convening to try and find a way to build bridges in our work to ensure that survivors were not falling through the cracks. And the gaps and opportunities were pretty palpable. CSAJ launched a project at that time called the Consumer Rights for Domestic and Sexual Violence Survivors Initiative to help build partnerships and also build capacity in the field to address consumer rights. And one of the key issues during the course of that time, and increasingly so, I would say, has been the issue of coerced debt. The deeper that we get into this work, the more we see that the most formidable challenges facing survivors, particularly survivors who are marginalized by virtue of their identity, are the barriers that have enabled and reinforced, or that the barriers that are enabled and reinforced by institutions and policies. So economic abuse isn't just, and coerced debt isn't just an interpersonal issue, but rather the inequitable laws, policies, and systems are really what has made the economic impacts so intractable. Perhaps nowhere is this more visible than in the context of coerced debt and its rippling effects. So for example, early on in my legal career, I worked with a woman who we will call Sally, and Sally had been physically beaten by her partner, resulting in huge amounts of medical debt. But it really wasn't until weeks after her partner had left her home that she received a bill in the mail for a credit card account that she had never opened. Her partner had used her name and her personal information to open an account and ran up over $15,000 in charges. Saddled with that debt, she worried about how she would pay for her utilities, how she would find new housing, and buy a car so that she could do things like get to work and be able to support herself independently. But it's really apart from those immediate effects that coerced debt has in burdening a survivor with economic obligations, it also damages, of course, a survivor's credit. It is common practice for employers to deny employment or landlords to deny housing based on an applicant's negative credit history. And there was a piece in the New York Times recently that was an expose illustrating how this manifests. So Shakira Crawford had fled from her abusive husband with her 3 children. And despite a 10-month apartment search, as well as reliable income from a full-time job, she and her children remained homeless. Landlords rejected applications due to her damaged credit and a previous foreclosure. And she also suspected that discrimination by virtue of race had played a really substantial role in the denial of her access to housing. Our credit scoring systems are rooted in a long history of housing discrimination and disproportionately impact communities of color, resulting in massive unequal debt obligations and inequitable impacts on access to credit. ProPublica had done an analysis of 5 years of court judgments from 3 metropolitan areas, St. Louis, Chicago, and Newark. And they found that even accounting for income, the rate of debt collection judgments was twice as high in mostly Black neighborhoods as it was in mostly white ones. Companies now routinely use the courts to pursue millions of people over even small consumer debts. With the power granted by a court judgment, creditors can seize a chunk of a debtor's pay. So really, we cannot talk about coerced debt without thinking about it in the context of institutional inequities and policy approaches that are rooted in systemic inequity for many, many generations. Given the collateral consequences of debt and the impact that credit has on employment, housing, and other critical resources needed for survivors' safety, we believe that we must address its profoundly negative consequences on survivors' long-term security. And given the economic inequities disproportionately experienced by communities of color, we cannot do this work without centering race and other forms of social inequity. CSAJ currently does some of that work with all of the folks that are on this panel in the form of a national coerced debt working group, which is comprised of lawyers, advocates, academics, researchers, and policymakers across the country who sit at the unique intersection of domestic violence and consumer and economic justice. This brain trust of activists is at the cutting edge. And over the last 2 years, the working group conducted interviews to inform what will be a coerced debt handbook for lawyers and advocates. The working group is also developing a national policy agenda on coerced debt and creating policy language, model policy language to guide federal efforts, offering support to state legislative efforts, and also responding to emerging policy and impact litigation efforts through comments, testimony, data, and narrative. Our most recent success was last week when we learned that the reauthorized Violence Against Women Act passed and now includes an economic abuse provision that was crafted by working group members. These are critical changes that need to occur for individuals to be able to equitably access relief. By addressing coerced debt in its structural context, we will open pathways to economic opportunity and expand agency and safety for all survivors. We see that as our call to action. Thank you.
Thank you so much, Erica. And that is very exciting news. So thank you for sharing that with us.
Oh yeah, thanks to everybody for making it happen.
Next, we're going to hear from Carla Sanchez Adams about how consumer protection law helps survivors and what are some of the gaps in the law.
Can y'all hear me?
Yes, we can. Thank you.
Y'all will have to bear with me because I have a really bad cold. So hopefully you can hear me. I'm going to share my screen just because I sound really bad. I just created a couple of slides so you can visually see what I'm doing, what I'm saying. Can y'all see that?
Yes, we do.
Okay, perfect. So yeah, I mean, one of the things that I wanted to address, and there's a bunch of different ways to start. And if I was in the room with you, I would draw on your whiteboard so I can circle and show you all what, how I conceptualize this in my mind. But as a litigator who, represents victims of coerced debt, there's different parts of the analysis that go into how we can protect consumers using consumer law. And then, there were areas that we couldn't, of law that, and you'll see as I present, of gaps that just, there was nothing we could do. And so one of the things that here in Texas we sought about doing as a coalition was to change the law so we could help all survivors of domestic violence in the context of coerced debt. So the first thing to think about in the context of coerced debt is what problem are you going to tackle? Because coerced debt has impacts on the victim, as both Angie and Erica mentioned. One of the biggest ones is the reporting of the credit itself. So consumer reporting in the US is vast. And if you as law students, I assume some of you all took out student loans, and if you did, then the lender used a consumer report. If you are renting housing anywhere in the area of your school, which I'm sure is really expensive, they probably took out a background report, a housing or a tenant screening report, which is a consumer report. If you will, when you graduate, you'll apply for a job, and it's very likely that some of those employers, because you're getting paid more than $75,000, are going to be checking your employment background, especially if you're going to work for a federal government. They're certainly going to be employing a company that checks your background. So all of this is consumer reporting. It's very broad. And so for victims, if they have negative credit because of the coerced debt that was taken out in their name, then they're not going to be able to get a car. They're not going to be able to get housing. They're not going to be able to get that job because they have bad credit. They have negative credit that has been impacted. So that's the first thing we think of, is how can we fix that? How can we make sure that all that bad credit that's on there, shouldn't be on there, is removed? So that's one thing. The second part is the collection of the coerced debt. So that means getting sued on that coerced debt. That means getting collection calls, texts, emails, letters, repossession, foreclosure, all of those things. That's the collection of the coerced debt. So in those frameworks, there's separate laws that apply. And part of it is going to be the question of, okay, well, what laws will apply depending on what protections exist. So as Angie mentioned the definition, there is the coerced debt piece that is the traditional identity theft, right? I didn't know about it. I didn't consent to it. I didn't, sign it. None, like I had zero involvement in this credit transaction, traditional identity theft. And there are laws that protect survivors in that context. So you can definitely use the gamut of consumer protection laws for those victims. However, in the piece that they mentioned of coercion and manipulation, right? Like I was forced to do it because fill in the blank, right? They would hurt my pets, they would hurt my kids, they would hurt me, they would, psychologically abuse me, all of the different things, or they lied to me, they manipulated me, all of those. There were no traditional defenses at law that applied for victims of coerced debt in that bucket, right? There was creative arguments you could make under contract law. If the lender saw the duress going on and was part of it, then potential, or was part of, him forcing her, pinching her, and they could see that. There were arguments that could be made, but they didn't fit under the protections of someone who was an identity theft victim. And there was very little that could be done in the consumer law context. Certainly there have been advocates who've tried to achieve some kind of help through the family law context in a protective order or divorce if they were married, but that has no bearing on consumer law and on collection or reporting of the debt, regardless of what a divorce decree says, regardless of what the protective order says. So that's where the gap was. And then I'm going to skip ahead and then go back. So that, in Texas, one of the things that we're part of a coalition on coerced debt, Texas Coalition on Coerced Debt, we were discussing these challenges, and me as a litigator was saying, it's horrible that I can tell half of my clients, oh, some of your debt I can deal with under consumer protection law, some I can't. What are we going to do? Or get a bankruptcy. That was generally what we would say, is take out bankruptcy to get all of that debt taken care of, so it's not staying on your credit and you're not being collected for it. So what we generally want to do, what we sought to do, was change the definition of identity theft in our state. And so we did, and that means that we can, we changed it to include in the definition that you have to have given consent or effective consent. And effective consent is defined, it's not effective consent if it's done under force, threat, or duress. So now all victims of coerced debt as of September 1st of 2019 can avail themselves of identity theft protections that exist. And some of those are, there's federal protections under consumer law, and then there's state protections. So in California, you all have a strong identity theft statute. Unfortunately, it does not include the coercion or the manipulation. It only includes traditional identity theft until your all's law gets changed. I know Sabrina's going to talk a little bit about what California is doing in regards to coerced debt victims. But the statute itself is strong, where you can sue the lender or the creditor, and you can get damages and statutory damages and attorney's fees. So there's state laws, and then the federal laws. There's I've listed some here, and I know y'all are law students and you probably don't even know about these laws, so I'm not going to get into them in depth. But they cover some of these transactions that I mentioned before, or that are here on your screen. So the challenge with consumer law is that because it is credit-related transactions are so broad, and you see here a list of them, right? There's not one law that covers all of these, except for the reporting of it. So the reporting of the debt is all covered by the Fair Credit Reporting Act. So that's like the linchpin of a lot of the law. If you can take care of the reporting, if you can make sure that it's removed or it's blocked from appearing on a report, then you've won half the battle, or I'd probably say 80% of the battle, because a lot of our clients are judgment proof if they get sued on collection. So that's the one, all of these will be covered because all of these are likely going to be appearing on a credit report. However, as to the second prong of back up here that I mentioned, the collection piece, each of these have their own laws. So credit cards have their own law, the Truth in Lending Act. Auto loans, you have their own law. All of these have their own federal or state law that governs. And so you may have defenses that you need to look with, but they do exist. So specifically for credit cards, there's a law that exists that touches on identity theft, and as well as debit card theft. So if somebody uses a debit card or an ATM card to steal the survivor's money, there's a law that covers that. But outside of those already established laws, there's some creative thinking that you've got to do if you're representing these victims outside of Texas and outside of Maine. Maine also has some strong laws for survivors of economic abuse. So they have laws on the reporting of the debt, as well as collection of any debt that resulted from economic abuse, which is actually more broad than just coerced debt. So I know I've covered a lot, and I told them I can't cover everything in 10 minutes, but there's your broad overview, and I will pass it now to Sabrina.
Thank you so much, Carla. That was really interesting. And yes, we're very excited to hear next from Sabrina about some of the policies passed in California and current advocacy efforts. This is a topic that is being very actively worked on right now. So we're going to next hear from Sabrina. And there she is.
Great, y'all can see my slides, okay?
Yes, we can.
Awesome. So hi, everyone. I am Sabrina Hamm. My pronouns are she, her, hers, and I'm the Director of State Policy and Advocacy at Free From. And Free From is a nonprofit organization. We do national work. We're based in Los Angeles, really trying to create pathways to long-term safety for survivors of intimate partner violence, really taking a holistic approach, sort of what can we do to bring every pillar of society in addressing intimate partner violence. So I'm just going to I just have a couple slides here about some of the current or past legislation, and then some upcoming and pending legislation in California related to coerced debt. So just a couple years ago, AB 2517 by Assemblymember Gloria was passed, which adds language that RO, so restraining orders, may include a finding that specific debts were incurred as a result of domestic violence and without the consent of a party. And so essentially a judge can make a claim that a particular debt was coerced, and but the challenge with this bill is that it doesn't really provide the relief. So this is sort of inching closer to one, recognizing that survivors are being impacted by coerced debt, but not really, there isn't that level of protection that survivors need for this bill. And then so last year, AB 430 by Assemblymember Grayson was passed, which made the FTC, so the Federal Trade Commission identity theft report, as sufficient evidence that a debt was incurred fraudulently. And so this bill really, I think another important aspect of this bill is that it codified that debt collectors cannot require a survivor to produce a police report. And so prior to this, the law gave a lot of flexibility for creditors to demand various documentation, in particular a police report. And so this gives survivors an additional option in recognizing that a debt was incurred through identity theft, which is a much narrow definition, and not including the more expansive definition of coerced debt. And so these two laws were passed over a couple of years, which really inches a little bit closer to providing survivors some relief, some recognition that they've been subjected to coerced debt. And so we have a couple more bills that are in play this session. So in 2022, both of these bills have been introduced or pending. So SB 975, which would be a really much stronger bill than the previous two bills that I mentioned, which creates an opportunity for survivors to be relieved of coerced debt, allows the survivor to bring a right of action to a creditor to claim that a debt was incurred through coercion by providing a long list of various evidence that they can show. So a police report is an option, and the FTC identity theft is an option, relevant court orders, and a long list of other documents by what they are calling certified professionals. So domestic violence service provider, therapists, et cetera, can sign and show that that this debt was incurred through coercion. And so this is going to take a much stronger leap in providing those protections for survivors, and also that relief for survivors, so they don't have to pay down a debt that they didn't incur. And then there's another bill. I didn't put up the bill number yet because it's still pending, but it's a bill that we're working on very closely with Assemblymember Grayson's office, which would require the Department of Financial Protection and Innovation, so the DFPI, to create a voluntary training on economic abuse for financial institutions. And while this bill isn't, directly related to I think this bill is really getting more at the broader issue of economic abuse, which also is very much related to coerced debt. And so, I think this bill is really trying to do a couple things. One, bring in financial institutions as a resource and a support for survivors, and then also creating a preventative measure so that financial institutions are able to identify, spot, recognize, and learn how to properly report or address or react, et cetera, to economic abuse, also including coerced debt. And so, really trying to look at the preventative side to prevent it from happening, or providing survivors with the necessary resources and support from their financial institutions. And a lot of banks are really doing things very similar when it comes to elder financial exploitation, and really looking at how can the work that banks are already doing on that front to be expanded to survivors of intimate partner violence. And so these are the two bills that are introduced and still pending. And if you'd like to stay updated, you can feel free to email me or get in contact with me in some way, and I'm happy to keep you all updated on that.
Thank you very much, Sabrina. So now we are going to take questions. Do we have any questions at this moment? In the room, feel free to throw questions in the chat as well. I'm going to pin the speakers so that we can see, see them more clearly here.
Hi, my name is Michaela, and I just wanted to thank you all so much for taking the time to be here. I'm really interested, I guess, in how states and advocates can continue to innovate. And I'm curious as to how, I guess, specifically for Carla, maybe the recent CDIA decision in the First Circuit, how that kind of opens the door for advocates to kind of innovate on the state level.
Yeah, it's a great question. And we were actually just talking for the Texas Coalition on Coerced Debt, our strategic planning committee. We were talking about policy and, building on what we already did, right? So now identity theft protections are available to all victims of coerced debt, but how do we bump up protections for identity theft victims in Texas? So we were thinking about our debt collection law, and potentially now that that decision has come out, credit reporting as well. So for those of you that are watching and don't know what the question was referring to, the state of Maine, as I had briefly mentioned, passed a law saying that the consumer reporting agencies can't include any debts that were a result of economic abuse on credit reports, on consumer reports. So that was challenged as a preemption issue, essentially saying that the Fair Credit Reporting Act, which is a federal law, preempts that new law. And so we were, in addition to that, they had also passed a medical debt reporting law. And so the First Circuit, it was basically the district court said, yep, preempted, got appealed. First Circuit said, well, not based on this reasoning, but we need some more information. You didn't really brief the economic abuse one. They did the medical debt quite a lot, but they sent it back to be heard again. And then the CDIA issued a request for a rehearing en banc, and that's where it is right now. So, I'm not sure yet how it's going to come out, but what might happen is that there'll likely be a circuit split on this issue, because there's already circuit splits on preemption as it is on other issues, other credit related laws all over the country. But I think that watching that carefully and seeing how it comes out does give hope that there's, that other laws can kind of push that bound. And if it comes out that it's affirmed, then, I think that signals that other states that are in better, like y'all are in the Ninth Circuit. So I think you guys are good, but us in Texas, we're in the Fifth Circuit. So it's like, oh, right now there's another law, we passed medical debt reporting law that also got challenged by the CDIA for preemption issues. So we're watching that to see how it comes out, to see if we can also do that, in absence of federal legislation. But I should also say that the CFPB is currently, there was a bill that was passed that touches upon reporting of debt from trafficking victims. And so the CFPB has been charged when that law was passed to come out with regulations, with rulemaking on what that looks like. And so we are in the talks with CFPB, hoping that they make some of their rulemaking on the FCRA a little bit more broad to also include economic abuse provisions and things of the like. So there's a lot going on, and I think that gives hope for states to do that, where, I think to be involved in conversation with stakeholders and see what's politically possible and strategically possible. But that was a great question.
Other questions? While you think of your questions, I would also just add quickly that another aspects that made the CDIA case in the First Circuit kind of exciting was that when they read, the way they read the medical debt portion of Maine's law was to look at the FCRA in a really expansive way, instead of in a more limited way to say, if it's not listed, then you can't regulate it. They said, well, if it's not excluded, maybe you can. So that was another sort of aspect of that case that is also, giving us some hope for future regulation of credit reporting, which traditionally has been very challenging. Other questions for our panel? Oh, I know you all have some. Well, we did start to chat a little bit, Carla, you mentioned victims of human trafficking. I wonder if perhaps Angie, Professor Littwin, if you want to just briefly mention some of the other populations that are affected by coerced debt and how that shows up, because we mostly have been focusing today on survivors of domestic violence, but this is actually an issue that crosses more vulnerable populations.
I think Erica might be a better person for that question than I am, because that's more what CSAJ does. Although I can say that we've, people have mentioned elder abuse, and every time I give a talk on coerced debt to attorneys, I hear about people whose clients experience elder abuse that ends up resulting in debt, involuntary debt for them.
So, I mean, my thoughts on that are, yeah, of course, survivors of, apart from survivors of intimate partner violence, we're also looking at the ways in which trafficked survivors and survivors of elder abuse experience coercion, and of course all of the kind of analogous ways that coercive control sort of operates. But I think more specifically, just in the area of I'm seeing Carla's chat here, right? Elder abuse, foster youth, trafficking. But in the area of domestic violence, some of the work that we've done is trying to better understand the ways in which coerced debt impacts different marginalized populations differently. So CSAJ's Access to Justice project has conducted a number of peer exchanges that are pulling together groups of advocates and lawyers to talk more specifically about what survivors' lived experience looks like in the coerced debt realm for LGBTQ survivors, for survivors living in rural communities, immigrant survivors. I'm trying to think if there have been other populations where we've had those more focused peer exchanges. And certainly, yeah, in our COVID study last year, there was data about the ways that coerced debt was showing up for survivors who were at the margins by virtue of identity. So there is data there, and I think lots of work to be done to better address how those lived experiences operate differently.
So, and you raise your hand, please. This is Ted Merman. I direct the Center for Consumer Law and Economic Justice here at the law school. I also run the California Low Income Consumer Coalition, which is one way to get involved in efforts in the California legislature. Sabrina and I have worked together for years in that particular effort. But I had a question that is often asked at this sort of thing, and let me ask the panel. You are facing a room largely of law students. Is there a way that they can get involved in this effort, both as law students and once they graduate?
Well, I mean, I think that the main one is to, depending on what you want to do with your law degree, right? Whether you want to go into policy or litigation or clerking for, federal judges or things like that. There's so many ways that you can impact this client population. Understanding this dynamic is a big part of it, right? Acknowledging that it is something that exists that impacts survivors is the first step, because I know that when I litigate on these issues, the opposing counsel often say, well, and creditors alike say, well, it's the person's address, it's their social security, it's the same person, and they were married, and all of these kind of archaic ways of looking at identity theft, and looking at our financial system, and just through the lens of whatever you end up doing, right, is thinking how will this affect this population in particular? How do these policies, how does this law impact the domestic violence survivors, human trafficking survivors, the least of these, if you will. But aside from that, just changing the way you think is, doing the work, right? Being a consumer lawyer, being a family lawyer that helps survivors in the consumer law context as well. Being so I was a legal aid attorney for 13 years. I'm now transitioning to the National Consumer Law Center to do more policy, but do the work, represent the clients. That's my pitch, is going to always be, be on the ground representing victims of coerced debt.
Yeah, we desperately need more Carlas, right? We're realizing at one of our recent Texas Coalition on Coerced Debt meetings that Carla's leaving for the NCLC, and there's going to be a complete gap there now. And how are we going to possibly fill it? So following in her footsteps, right, is like number one way you can get involved. But if you're not going to go into public interest full time, there's also plenty of pro bono opportunities, and pro bono policy work, right? There's just a lot of room to get involved. Yeah, you all are in California, but if you're moving to Texas, definitely get in touch with us. But if you're in California, probably Sabrina might be a closer connection.
So I would
Yeah,
add, sorry.
Go right ahead, Erica.
No, you go.
Okay, I was going to say there's a number of consumer coalitions in California for those who are interested in joining or participating. Free From, we host a monthly survivor wealth policy working group where we bring advocates, direct service providers, survivors across the nation to really think innovatively about potential policy solutions, law changes, and things like that. And folks are more than welcome to join and participate in that. And I think if you're most interested in sort of tracking some of the legislation that I present today, maybe reaching out to me or some of the offices and things like that of how you can support that work.
I was just going to add that so the Coerced Debt working group that I talked about a little bit earlier has a lot of efforts underway, different subcommittees pursuing different work. So I would imagine that there will be ripe opportunities for research there if there are law students interested in either volunteering or doing some pro bono work there. And then I also just want to say, on the note of that we need more Carlas, that Carla created a project, and I think it speaks to the need for there to be partnerships that really bring together the two areas of domestic violence advocacy and consumer rights representation. So that kind of partnership building is something that has been done in a handful of communities across the country. And I would just encourage folks, as you step into whatever your new work is, if it has some aspect either of domestic violence or consumer rights, to think really innovatively and creatively to make projects that really build bridges between those two areas.
Thank you. Yes, one more, maybe perhaps one more question.
What do potential solutions look like for stopping coerced debt like from being created in the first place? Is there like regulatory duties for creditors, or is it just like stop these like environments from happening in the first place kind of deal?
Yeah, I'll tackle part of that, and then I know that other people here can talk about policy solutions for where there aren't any protections. So, the one big protection that I tell our clients is to get a security freeze or credit freeze, which is on your credit report. And that is, it essentially means no lender, no one who's going to try to extend you credit can access your report. It's just frozen. So even if the survivor wanted to take out credit, they can't unless they lift the freeze. That's the most secure way to stop it from continuing to happen after it's discovered, as far as like a legal mechanism. Outside of that, the challenge is that I know all of you guys are younger, or I'm assuming that because you're in law school, maybe it's your second career, but all of y'all have now seen that there's been this explosion in the last 2 years of financial technology, right, online, where you can do almost anything online and traditional banks are closing. And so because of that, identity theft in general is more rampant, and the ability to just take out credit and to do anything you want to online without confirming someone's identity is so easy. So Angie, that's one of the things that she talked about in her article, is that the depersonalization of credit has led to them being unwitting participants in this coerced debt scheme. And so unfortunately, when we do the policy work that I'm stepping into now is in that area of financial technology. That's one of the things, is like, we have to protect people's privacy and security, in addition to being innovative, because yes, we want people who aren't traditionally allowed to access credit in the past, right? So minorities and people who are called credit invisibles, we want them to be able to have access to these, innovative financial tools, but we also don't want it to be the case that now, I can lose my identity so quickly, and then I can be stuck in debt because somebody did all of these things online so easily. So as far as existing, there's that one aspect of the credit reporting. There's those laws that if somebody has unauthorized use on your credit transactions or on your debit card, there's some protections in place that I mentioned, but outside of that, there really isn't. You'd have to file a lawsuit as a consumer just on fraud in general to say, hey, this wasn't me, this wasn't my contract, I didn't sign this. And so that's an unfortunate, and that's putting it mildly, but that's just not acceptable, right? There should be easier avenues for someone to fix those problems. So I'll let others chime in after.
Well, I'll say that one thing we're currently limited by is that we don't have a lot of sort of systemic data about how it works. And so Adrienne and I have had a grant from the National Science Foundation, and we've collected the data, and now we're processing it and hope to begin analyzing it very soon. And then I think we'll have a lot more information about the how, and we'll be able to identify places where financial institutions might be able to intervene, or what it might even begin to look like once we have that sort of wealth of data mapped.
I think to add is just, I think a lot of financial institutions are really hesitant in sort of seeing what they can do to prevent economic abuse from happening. And I think there's a huge sort of education piece that needs to happen with debt collectors, credit unions, banks, etc., on how they can increase, what does a safe account look like for survivors, for example, like additional heightened security measures, maybe 2-3 step verification processes. And I think there's a lot of opportunity for banks to think more creatively about how they can better protect survivor accounts, their resources, assets, etc. And I think just them understanding the intersection of intimate partner violence, financial insecurity, and then how that relates to economic abuse, and also how that, how coerced debt is also included in all of that. And there's banks who are sort of trying to do that or thinking about that, but there's just a huge gap in including more banks and financial institutions more broadly.
Well, thank you all so much for being here. Let's give a big round to our panel. Lunch is right outside across the hall in the courtyard, right on this side. So feel free to go ahead and grab yourself some lunch, and we will see you at our next event. Thank you all so much for being here.